Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Well, Dateline, December 11th, 2023. As we know, the first son of America, your favorite first son, of course, that is Hunter Biden, is now facing several indictments for a litany of activity. The one that we care about here, of course, was apparently lying on a Form 4473 saying you were not an illegal user of controlled substances when in fact he was strung out on crack cocaine nonstop. Now, as we know, there was a plea deal struck, but then of course that got swept away and now away we go. There are new indictments and it appears that the first son is really embracing his Second Amendment rights. Contrary to what his dad might say about it, I think the son may have a different opinion. So today, let's spend a few minutes to take a look at some pleadings and talk about when the first son starts embracing the Second Amendment. Okay, so the case we're talking about today is United States versus Robert Hunter Biden. This is a case which is brought in the United States District Court for the District of Delaware. Now, amongst the litany of allegations against Mr. Biden, some of the allegations here include that Mr. Biden lied on a Form 4473, specifically down in Section 21, where he stated that he was not an illegal user of controlled substances when in fact apparently he had a horrible crack cocaine problem at the time, answered the question in the negative and was able to receive a firearm. Now, I get that a lot of you have strong opinions about the Biden family. I share most of those opinions, and you may have strong opinions about Hunter Biden himself, and I probably share most of those opinions as well. However, what I'm here to do is to assess the work that his lawyers are doing. And what a lawyer's job to do is to advocate to the fullest extent of the law whatever is in the best interest of your client. And I will tell you that Mr. Biden's attorneys are doing exactly that. These are the exact arguments I would be making if I had a client in a similar position. Let me explain to you in their motion to dismiss these counts of the indictment, because that's what they've done here. They filed a motion to dismiss it saying, hey, listen, you're going to try to prosecute him under a law which is unconstitutional. Counsel for Mr. Biden points out the prosecution charges that Mr. Biden violated a rarely used statute that it claims prevented him from owning a firearm as an unlawful user of controlled substances, 18 U.S.C. Section 922 G3. But that statute's status-based prohibition on gun ownership recently was struck down as unconstitutional under the Second Amendment. And they cite to the United States v. Daniels case, which of course is now being petitioned to the United States Supreme Court by the United States government for review. Defense counsel then further states, not only does the unconstitutionality of Section 922 G3 render Mr. Biden's alleged violation of that unconstitutional statute baseless, it compels the same conclusion as to the prosecution's charges that Mr. Biden made a false statement in denying his status as a user of controlled substances under 18 U.S.C. 922 A6 and caused the seller, a holder of a federal firearms license, to maintain a record of this false answer in violation of 18 U.S.C. Section 924 A1A. And so I do got to admit here that the United States government did pile it on Mr. Biden here, because in addition to charging him with the one obvious crime, you were a user of controlled substances and in possession of a firearm, they then charged him also with making a false statement on the Form 4473. That's count 2 on this. And then third, helping create a false record that would then be maintained by the FFL since they have to keep the 4473s. So you want to talk about building a mountain out of a mole here. Here's 3 felony charges coming from 1 criminal act. Because persons protected by the Second Amendment can no longer be denied gun ownership due simply to past drug use, a practice inconsistent with this nation's historical tradition on firearm regulation, any false statement by Mr. Biden concerning his status as having used a controlled substance no longer concerns, quote, any fact material to the lawfulness of the sale, end quote, of a firearm. Quite simply, asking about Mr. Biden's status as a user of controlled substances is constitutionally irrelevant to whether he can be denied his Second Amendment right of gun ownership. Okay, so did you catch that? Because when this first started breaking, I was kind of like, hey, listen, I understand how some of these arguments that are kicking around, in cases like Daniels, in cases like Range, how this could do away with the charge of being a user of controlled substances while in possession of a firearm. But I always was wondering, how are you going to skin the cat when it comes to the fact that he also lied on a federal form? And as you can see, what the defense counsel is doing here, and I think this is a smart argument, is they're saying, listen, the question is getting into constitutionally irrelevant material. Therefore, since the question is irrelevant, so is the answer, and therefore the criminal statute that he's prosecuting under is null and void. And of course, while the Biden administration may be incredibly critical of that renegade court with that reckless Bruin decision, no defense counsel for Hunter Biden, no, they are fully embracing it. In truth, the statute is indefensible under the Bruin framework. Daniels appropriately recognized that the framers were well aware of the problem caused by intoxication, but there is no historical precedent for prohibiting gun ownership by persons who had any history of ingesting intoxicating substances. Rather, the problems associated with intoxication were addressed by prohibiting certain conduct while intoxicated. Now, let us remember that the Daniels case is one that involves a sporadic user of cannabis who was also found to be in possession of a firearm. Mr. Daniels has prevailed in front of the Fifth Circuit on that, and the United States now has that case on certiorari before the United States Supreme Court, hoping for a review of it. But I think defense counsel correctly points out, given the lack of any historical precedent for disarming citizens based on their status of having used a controlled substance, the fact that Section 922G3 violates the Second Amendment is inevitable under the Bruin framework. Now, in addition to citing to the Daniels case time and time again, defense counsel also cites to the Rahimi case, which has now been argued before the United States Supreme Court, awaiting an opinion. And then very interestingly, also cites to a Third Circuit case, the circuit where this case would likely end up, of Range versus Attorney General of the United States, which I think is a fascinating case. And I am also hopeful that the United States Supreme Court accepts review on that, because that deals with a nonviolent felon who is basically precluded from restoring his gun rights for the rest of his life. As defense counsel points out here, if confronted with this very issue, there is no reason to doubt that the Third Circuit will agree with the Fifth Circuit, the only circuit to have considered the constitutionality of Section 922G3 post-Bruin. The Bruin framework is clear, and the historical record is immutable and the same before this court as it was when the Fifth Circuit addressed it. And again, I always thought that the biggest challenge for the defense attorneys here were going to be like, what about the lying on the form? Maybe that whole prohibition about being a controlled substance user and having guns, that is unconstitutional. But what makes a statute unconstitutional for actually lying on a federal background check form? This is how defense counsel very creatively and I think intelligently crafts their argument. Now that Section 922G3's ban on gun ownership for those who have used a controlled substance is unconstitutional, this question on the form about whether a gun purchaser is a user of controlled substance is irrelevant to the lawfulness of the sale. In other words, neither the question nor the answer to it is a fact material to the lawfulness of the sale. The same is true of count 2 because Section 924A1A's requirement of maintaining records free of false information is not implicated by Mr. Biden's answer to a question that the unconstitutionality of Section 922G3 now makes irrelevant to whether he could lawfully purchase a gun. So listen, I think that Mr. Biden's defense team has done a good job. They have put forward the correct arguments. Now, I recognize that none of us here are probably big fans of the Biden the Biden family. However, I am a huge fan of equal application of the law to everybody in a similar situation. And I think many of us would agree that if it was somebody else who had been in this situation, these would be plausible legal arguments just as they are here. The case, once again, is United States v. Robert Hunter Biden. We will link all of it up down below so you can geek out on the motion for yourself. And obviously, this is a high-profile case. There will be many developments, and we will keep you apprised. Now, in the meantime, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is down there in the description box as well. Now, in the meantime, I want everyone to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.